Welcome back to Are You Smarter Than a Libertarian, the only show where we dig through the Constitution like it's a treasure map and remind you that your rights don't come with a receipt from the government. I'm Jeff, and today we're cracking open the most mysterious amendment in the Bill of Rights, the Ninth Amendment. You know, the one that basically says, hey, just because we didn't list every single right doesn't mean you don't have them. Yeah, that one. We don't really talk about it. It's kind of like Pluto. It's an afterthought in the world. Now, let's get into it. First, we have to know, what is the Ninth Amendment anyway? The Ninth Amendment, and I quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, we all need a translation because there's a lot of words in there a lot of people don't understand. I don't understand some a little bit. Translation. Just because the Constitution lists some rights doesn't mean those are the only ones you get. It's like your friend who says, these are just my top 5 favorite bands. That doesn't mean they hate every other band. Same with the Bill of Rights. Those first 10 weren't meant to be an exclusive VIP list, even though we all like exclusive VIP lists because it makes life easier. James Madison, the OG rights nerd, pushed for this amendment to stop future politicians from getting clever and saying, well, if it's not listed here, it doesn't exist. Sorry, Congress, nice try. The founders fight over this back in the 1780s. There were two parties, the Federalists and the Anti-Federalists. First one we're going to talk about is the Anti-Federalists. The Anti-Federalists were side-eyeing the Constitution hard. Their fear that without a Bill of Rights, the federal government would turn into King George 2.0 or King Washington 2.0. And if they only listed some rights, the government might trample the rest. All valid concerns, especially this day and age. Now, the Federalists, like Madison said, chill, the government only has the powers we give it. But to get the Constitution ratified, Madison added the Bill of Rights anyway, including the ninth, as a kind of constitutional disclaimer. This is not a complete list, folks. Madison basically added the don't get cute. Now we have natural rights and enlightenment. Really interesting combination. Natural rights and enlightenment swag. The Ninth Amendment is pure enlightenment fire. John Locke would have been proud. It's built on the idea of natural rights, rights you're born with, not handed like a trophy from the government. We have a lot more rights that people just get handed by the government that are not actually natural rights. We're talking about privacy, bodily autonomy, the pursuit of happiness, stuff that didn't need to be written down because they existed before the ink hit the parchment. The Constitution was never meant to be a menu of liberties. It was supposed to limit government, not people. That's why I say freedom of speech is meant to restrain the government, not businesses and not private individuals. Now, the Ninth Amendment doesn't get talked about a lot, but it did make some Supreme Court cameos. And some very important ones, too. The Ninth Amendment doesn't get top billing at the Supreme Court. It's like the character actor of constitutional law, always supporting and rarely starting. First one we're going to talk about is Griswold v. Connecticut, 1965. Married couples couldn't use birth control. Seriously, but Massachusetts was a heavily Catholic state. The court struck this down and said penumbras of privacy. Yes, penumbras. And it cited the Ninth Amendment. I did a video about what a penumbra is. Then you have the great case of Roe v. Wade, 1973. The court nodded at the Ninth while riding the 14th Amendment train on abortion rights. That was overturned in 2023 or 2022. Richmond newspapers, 1980. Even access to criminal trials got a shout out from the Ninth. courtesy of Justice Rehnquist. I actually read a book about him when I was doing political science in undergrad. It's a phenomenal book. Then you have Planned Parenthood v. Casey, 1992, and Lawrence v. Texas, 2003, that follow suit, touching the ninth without depending on it. It's like the amendments always invited you to the party, but never lets loose on the dance floor. We all have that one friend that's like that, and I might be that friend. Activist versus restrained interpretations. And there are two camps, just like you had the Federalists and the Anti-Federalists. Camp A, the living Constitution crowd says the ninth means courts can recognize rights not written down because, duh, not everything fit in 1791. I kind of see that, but I'm more of a Camp B. The originalists, like Justice Scalia and Justice Thomas, said, hold up, the ninth didn't give you new rights, it just means we didn't erase the old ones. So what do you guys think of this? Let me know in the comments down below. So you've got one side trying to evolve the Constitution and the other side clutching the powdered wig screaming, stick to the script. And this is why you rarely see a court lean solely on the ninth. It's vague. It's a legal gray area, and judges, they don't like legal gray areas because their judgments can be overturned. So you might be asking, Jeff, what does this do for us today? Now let's talk modern relevance. Privacy, your data, your body, and your bedroom. The ninth helps support these ideas, but courts prefer to route through the Fourth or the 14th Amendments for clarity, which makes sense. You want something in a gray area to be buttressed by something else. Emerging tech. Could it help you fight back against AI surveillance or government-mandated brain chips by 2045? Maybe. But good luck finding a judge brave enough to plant a flag in the Ninth Amendment. It's like planting a flag in sand. Federalism. It reminds Washington that the people and the states retain rights. It's like the Constitution's way of saying, stay in your lane, buddy. It's a libertarian goldmine. If you're into medical freedom, lifestyle autonomy, or telling Uncle Sam to kick rocks, this is your amendment. And here we have a big problem with the Ninth Amendment. It's the problem of being vague. The Ninth Amendment sounds awesome until you need it. It's too vague for courts to hang their robes on. Instead, they use the First, the Fourth, or the 14th. Like I said before, judges like clear rules, not philosophical vibes, even though most jurisprudence is based off of philosophy. And let's be honest, most Americans don't even know the ninth exists. It's like people forget that Pluto was once a planet, now a dwarf planet. Ask around and you get, is that one about search warrants? No. That would be the fourth. Nice try, but try again. Now, it's not all gray area. It's the hidden armor of liberty. That's what the ninth is really all about. It's not about creating new rights on the fly. It's about preserving the ones that always existed. It's a safety net, a legal flashlight in the dark corners of government overreach. It reminds us that the people, not the state, are the source of liberty, as it should be. So next time someone says, well, it's not in the Constitution, go ahead and tell them, yeah, it is. It's in the Ninth Amendment. As I tell people all the time, it's in the Ninth. And at the Ninth Circuit Court. Thank you for watching and listening. If you're on Rumble or YouTube, please like, comment, and subscribe and share. If you are listening on Apple Podcasts, Spotify, iHeartRadio, please leave a review and follow. Until next time, when we hit the Big Ten, stay free, stay informed, stay accountable. Have a great day.